Greetings and welcome to another episode of American Jurisprudence, Records and Record Keeping. And just checking the levels here. Looks like the mic level's good. All right, and we got Audit Them in the house. Come on, show up here. Hang on a second. Oh, there we go. Why that's not there we go. And we're going into American Jurisprudence. Okay. There we go. Now we got some functionality happening. Give me a moment here. Let's get the American Jurisprudence up and zoomed in properly. Let's get to where we need to leave off from. And there we are. The remedies to enforce the right to inspect public records. And before we get there, make sure you get out your number 7 Esquire pen and take notes, or have a photogenic audio memory. And we'll be using Black's Law Dictionary 9th edition for definitions of words. Give me a second here. There we go. Get this guy zoomed in a little bit there. And there we go. 9th edition. And let's get started. So, let's see here. Yes, we're ready to go. So, the remedies to enforce right to inspect public records. So, let's get right to the meat of it here. Mandamus is an appropriate remedy to compel compliance with a statute requiring disclosure of public records. So from the first word, we have to go consult Black's Law. So let's get right to it and figure out a good definition of mandamus for mandamus. Here we go. So mandamus, it comes from the Latin. We command. 16th century. A writ, meaning a written notice, it should be of issued by a court to compel performance of a particular act by a lower court or a governmental officer or body, usually to correct a prior action or failure to act. Also termed writ of mandamus, a mandate, order. So let's see here. It's a mandamus. It's a writ issued by a court to compel performance of a particular act by a lower court or a governmental officer or body, usually to correct a prior action or failure to act. So a writ of mandamus, also termed. Let's look at some of the other versions and variations of this. It's not fitting on the screen. Sorry about that. Let's get this more centered. Yeah, that's close enough here. I'm only looking at this page right now. We have alternative mandamus. It's a writ issued upon the first application for relief, commanding the defendant to either perform the act demanded or to appear before the court at a specified time to show cause for not performing it. It's called an alternative mandamus. We have a peremptory mandamus, an absolute and unqualified command to the defendant to do the act in question. It is issued when a defendant defaults on or fails to show sufficient cause in answer to an alternative mandamus. So if they don't do this and you move to the peremptory mandamus, then there's a, this is mandans. This is different. Okay. So we have a few different versions here. We have the alternative mandamus, and it's upon the first application for relief, and then a preemptory mandamus, which is an absolute and unqualified command to the defendant to do the act in question. And it is issued when the defendant defaults on or fails to show sufficient cause in answer to an alternative mandamus. So this is racking it up a notch after the alternative mandamus, which is the first application for relief. So now I think we have a pretty good understanding of what they mean by this one word mandamus in American jurisprudence. Let's get back. All right, if everyone is here, please hit the like button and throw something in the chat so we know that I'm still streaming clean. All right, let's get back to it. So, mandamus is an appropriate remedy to compel compliance with a statute requiring disclosure of public records. Did you get that? So, a writ of mandamus or a mandamus is the appropriate remedy, but is not an appropriate remedy to prevent disclosure. So, the public official servant, the POS, can't use a mandamus as a remedy to prevent disclosure. Great, great. It's nice to know everyone's still here. Interesting, huh? So the procedure for handling a mandamus action to inspect records requires that the custodian first determine whether the record should be released. And if the custodian determines that the public harm in releasing the record outweighs the public benefit, the custodian should refuse the demand for inspection. For example, in an action in which a newspaper sought a writ of mandamus to compel a local board of education to release information regarding a settlement it had reached in litigation, the writ was granted because the settlement agreements entered into by a governmental unit are public records. Interesting, huh? This is something to be aware of. I think my mic volume just dropped, didn't it? No, it didn't. It's good. Okay, check. It should be good. So this is an interesting thing here. Settlement agreements. Are you aware of this, everybody? Take note. Settlement agreements entered into by a governmental unit are public records. And that's footnote 4. And that's state XREL Sun Newspapers versus Westlake Board of Education, Ohio. Let's see, 1991, Cuyahoga County, 8th District. So now, one of my favorite parts in American jurisprudence, the practice tip. Courts may perform, excuse me, an in-camera inspection of the requested common law public records as they balance the relevant factors in determining a requester's access to such records. And courts are authorized to require the redaction of the records to maintain confidentiality. And that's footnote 5. And that's Camden City Public School District. And that's New Jersey. So this Camden City Public Schools gets into a lot of these cases, I've noticed, in American jurisprudence. Let's continue. Reminder. Wait, did we finish this one here? No, we didn't. If a person seeking inspection then files suit to compel the inspection, then the custodian depends on the ground stated in the refusal. Let's break this down before we go on here. If the person seeking inspection then files suit to compel inspection, and the custodian depends upon the ground stated in the refusal, the trial judge should examine the record in camera to determine whether the harm likely to result to the public interest by permitting the inspection outweighs the benefit to be gained by granting the inspection. Wow, and that's number 6. And that's George versus Nick, and that's 1994. So this is some time ago. This would be an interesting case to look at. Where was this one? Wisconsin. 2nd District. All right, so this is interesting here. Courts may perform an in-camera inspection. So, of the requested common law public records as they balance the relevant factors in determining a requester's access. So, the courts can look at a record that the requester can't quite see so they can determine whether the redaction is necessary to maintain confidentiality. I get it. If the person seeking inspection then files suit to compel inspection and the custodian depends upon the grounds stated in the refusal, the trial judge should examine the record in camera to determine whether the harm likely. So the judge gets to decide this stuff and outweigh the benefit gained by granting the inspection. So it's up to the judge. That's a practice tip, is that if there is a situation where they don't want to release a record and you say they should, the judge can actually look at the camera, even just if it was an on-camera, in-camera inspection, and then he can determine or she can determine whether there is something that needs to be redacted to maintain confidentiality or if you should have access to the document, etc. And again, the court would have the last say in this because they can issue those that what was the last one we said, the peremptory mandamus, which would make this defendant do the act that's being requested. Beautiful stuff. So, reminder, now here's the other part that you never want to be too overly confident in your practice because you always have to watch for pitfalls. And that's another beauty of American jurisprudence is that you're looking at this case or whatever you're developing from all sides, from the opposite side too. You never want to stop to think about what your opponent or your counterpart will be considering for their next move. Just like in a chess game, you need to think a few moves ahead. These reminders and precautions that are in American jurisprudence are really vital for having that upper edge in being ready for the counter moves that you might encounter. Let's continue. So our reminder is, in litigation, the parties may use discovery procedures to gain access to any record, not privileged, that is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery, or to the claim or defense of any other party. Interesting here, huh? That you could use discovery. Where is it here? Discovery to gain access to any record, not privileged. Of course, privileged records, right, are ones that you're not going to get through discovery directly without, a compelled to produce motion or something of that sort. Before we go on, I just want to also remind everybody that this is really about an education, entertainment, interactive type of format, that I have absolutely no legal lawful knowledge at all to give to anyone. None of this should be construed as legal advice or actual information in any way, shape, or form, and do not try this at home. Let's proceed. Citizens' constitutional or statutory right to inspect public records. So now we're way at the top of the hierarchy here as far as supremacy of law. We're at the citizens' constitutional or statutory right to inspect public records. Now, I just want everybody that seems to dislike that word citizen, and I understand why, that in the context of this, it's not a limiting factor for anyone that's considering using this type of approach. This is strictly a way of having a clear construct of the rights afforded to the individuals that are being presented throughout these, the court actions. Let's continue here. Let's see here. In some jurisdictions, by constitutional provision, any citizen may inspect a public record, regardless of any nexus between the citizen and the governing body in question, and regardless of whether the citizen is subject to jurisdiction of a particular public body, subject to certain prescribed privacy restrictions. Let's read this again, because this is interesting. In some jurisdictions, again, American jurisprudence is a general approach, so it may or may not apply in your particular jurisdiction, and that's why it's explaining it in this particular manner so that we understand. You need to do your own research in your jurisdiction that this might apply or your situation may apply. But in some jurisdictions, so let's say for your state, by state constitutional provision, any citizen may inspect a public record regardless of any nexus between the citizen and the governing body in question. So what's a nexus? Nexus is basically a legal bond between something in the real world and something in the legal world. So if the person here or the people don't have to have any legal, written or otherwise connection with what they specifically call here a governing body. So you don't have to have any basic connection, bond, obligation, or otherwise for the governing body in question. And it's regardless of whether the citizen is subject to the jurisdiction of a particular public body. Notice we have here governing body and public body. Two things. So be very careful on the wording. So the governing body in question is where you would have a legal nexus, but a public body, regardless of whether you're subject to a jurisdiction. So here we have a legal nexus between a citizen and a governing body. Governing body means it's governing. It needs to have a way to govern, and that's through the legal nexus. And regardless of whether a citizen is subject to jurisdiction of a particular public body. So regardless of jurisdiction. So the jurisdictionary plea in something like this would not apply, is what they're trying to say. So this is a personal jurisdiction here because we're talking about the citizen. All right, let's continue. To a public body. So now we've just broadened this here. It's no longer a governing body. It's a public body. A governing body is one that is regulating, governing, and a public body is one that serves the public, subject to certain prescribed privacy restrictions. That's their disclaimer. And this is Shockley versus Cascade County, Montana, 2014. By statute, in some jurisdictions, every person has a right to inspect any public record, except as provided by the statute, rendering all public records subject to disclosure, unless legislator has expressly provided to the contrary. In other words, citizens' access to public records can be denied only when a law specifically and unequivocally can be citizens' access to public records can be denied only when a law specifically and unequivocally provides otherwise. Specifically and unequivocally. I've noticed they like this word specify and specificity and they like this word a lot. And unequivocally, specifically, and unequivocally provides otherwise. So these are bars of requirements for a public official or servant to deny any access to records. So it can only be denied when it's specific and unequivocally. Let's continue. A citizen's right of access to public records by statute may be defined by the requester's status in relation to the records sought. As for the lawful and custodian parent of a child whose school records are requested. So a citizen's right of access to public records by statute may be defined by the requester's status in relation to the records sought. As for the lawful and custodian parent, of a child whose school records are requested. So I guess this is number 4, Brown versus Lieberman, Ohio. I guess this is saying that if it's a public record, but they're not going to redact it if it's your kid or custodial parent. I guess that would fall into something like probate or something, or what's it called? No, never mind. Personal interest requirement for right to inspect public records. Interesting, a personal interest requirement. What does that mean? Well, before we go on, I just had a notice here that there's 8 people here. We need to hit that like button so that the algorithm knows what we're doing here and hopefully send some more. So access to a public record at common law requires that the person seeking access establish an interest in the subject matter of the material which outweighs the state's interest in preventing disclosure. That's number 1. Matter of New Jersey's Firemen Association obligation to provide relief applications under Open Public Records Act. And that's 2017 in New Jersey. Under common law, every person is entitled to inspect, either personally or by agent, public records, including legislative, executive, and judicial records. That's all 3 branches: legislative, executive, and judicial records. Do you see this? Provided that the person has an interest in them that would enable maintaining or defending an action for which the document or record sought can furnish evidence or necessary information. Number 2. 1976. McEwen versus Home. What state was this? Oregon. Jeez. Or is it Rhode Island? So that's 61, Oregon, and Rhode Island is 76. Got it. Okay, so let's see here. It says that, we're getting into really fine things here, but when you think about it, almost any public record you request may be considered you would have an interest. Any person does, because it's the people's duty to use public records to ensure there's evidence that the government is working in the public interest. The public records are the evidence that the government is doing what they say and saying what they do. Let's continue. The requisite interest necessary to accord a plaintiff standing to obtain copies of public records under the common law right of access may be either a wholesome public interest, like I just mentioned, or a legitimate private interest. Number 3. Excellent. And that's 2009. Law Center versus New Jersey Department of Education. Education Law Center. Interesting. 2009. The interest must, however, be particularized to the documents requested. Let's find out what this is again now. This is the requisite interest necessary to accord a plaintiff's standing to obtain copies of public record under common law right of access may be either a wholesome public interest or a legitimate private interest. The interest, however, must be particularized to the documents the public records requested. So you need to be particular about it. So far I've seen words like specifically and particularly and it's what was the other word? We had a few other ones. So let's keep track of these words because they're used in place of, I mean, they're used precisely in the places they are for the reasons that we're starting to see here. When you construct a case from the other side, when you're trying to make a complaint or to make a defense or affirmative defense, you need to be clear about things like particular and specifically as a bar to enter things in. So let's continue. An interest as citizen or taxpayer is sufficient interest to inspect public records. Boom. So I was talking at length for nothing, wasn't I? The common interest that every citizen has in the enforcement of the laws and ordinances of the community entitles the citizen to inspect the public records to ascertain whether the laws have been observed. Very clear. As a citizen or taxpayer, and remember, you buy a stick of bubble gum that's pay tax on it, you're a taxpayer. Beautiful. And that's number 6. Where's that? That looks like a 1948, 1995. So we have this is pretty well established. Let's read this again. Very well established. An interest as citizen or taxpayer is sufficient to inspect public records. That's dead simple statement here. Now, I think that anybody could understand this. An interest as citizen or taxpayer. An interest as citizen or taxpayer is sufficient interest to inspect public records. Common interest that every citizen has in the enforcement of the laws and ordinances of the community entitles a citizen. This is an entitlement to inspect the public records to ascertain whether the laws have been observed. You're entitled to this. Observation. Under the balancing test used to determine whether a person is entitled to access to public records, if the public entity asserts a claim of confidentiality to the records, the interest of the party seeking disclosure is more closely scrutinized. That's our observation. Do you get this? Doesn't say you're denied. Under the balancing test, this is it. This is all it comes down to. Remember, a balancing test is on the scale used to determine whether a person is entitled to access. Remember, it's an entitlement, which means that we can have that writ of mandamus if they don't honor this. Okay, so here's our balancing test. If the public entity asserts a claim of confidentiality as to the records, then that's on their side of the scale. The interest of the party seeking disclosure is more closely scrutinized. We need to get something on our side to equal it out. Got it? Good. Let's move along. Now we're on to legitimate purpose requirement for right to inspect public records. The right to inspect public records may be limited to only persons with a legitimate purpose, as may mean a purpose which tends to advance or further a wholesome public interest or private interest, as we read before. Thus, no one has a right under the common law to examine or obtain copies of public records from mere curiosity for the purpose of creating public scandal from motives merely speculative, or to further any improperly or useless end or purpose. Interesting here, isn't it? Now let's think about this in the context of what you see a lot on YouTube. Legitimate purpose tends to advance or further a wholesome public interest or private interest, like money, profit. That's fine. If you're doing it for money or profit, that's a private interest, I believe. But what's number 2 is a matter of New Jersey's Firemen Association obligation to provide relief applications under open. We saw this before 2017. Thus, no one has a right under common law to examine or obtain copies of public records from mere curiosity. So, as long as it's more than mere curiosity, which again, if we look back up to here, it seems like this is kind of a moot point, isn't it? An interest as citizen or taxpayer is sufficient interest to inspect public records. So we're back to here, and we see that right to inspect may be limited only to persons with a legitimate purpose, as a purpose may be which tends to advance further wholesome. So this seems like it could be, if you're just doing it again, do you see the beauty of American jurisprudence is that we're focusing on intent, not just the words of the law. This is what makes it so powerful, is that eventually you can construct the words and find the cases and find the statutes and the articles or whatever you need to find to back up this explanation of what's going on in a particular situation. But it's the intent that makes it worthy of being a case argued in the sense of law. If law doesn't have a basis or a nexus into intent, then what's it really serving? Is it serving man's code, or is it serving a more universal purpose, which is basically what the law is attempting to codify? And through American jurisprudence, in my opinion, to this day, it's the highest form of it we have in practice right now. Therefore, I find it a worthy cause to try to learn at the deepest level possible, and not only that, to compel those that we entrust with our public courts and such to follow this long-standing tradition of the American strength of jurisprudence. Let's continue. The right to inspect public records. Okay, so we got this part down. Useless and or purpose, and that's number 4. And again, this is West Virginia, 1965, Charleston Mail Association versus Kelly. So to cause trouble, sounds like about right. Yeah, public scandal, speculative or to further improper. Okay, so we see how that could be used, and of course, it's involving the press. Some things never change. Just in time. News media, right to inspect public records. So who's the news media? Let's see. The common law right of access to public records by a new media organization is limited to access sought to further a public good and is subject to a balancing of interests to prevent disclosure. The news media has no greater right of access to public records than the public generally. Oh boy. Did you see this? The news media has no greater right of access to public records than the public generally. Look at all these case laws for it. Leucadia Incorporated versus Applied Extrusion Technologies Incorporated, and that was Federal Third Circuit, 1993. Dixon versus Superior Court, California, 2009. Michigan, 1984. McLaughlin versus Philadelphia Newspapers, 1975. Okay, well-established law. The news media has no greater right of access to public records than the public generally. The right asserted by the news media in demanding access to information is the same as that of the public at large. The state's interest in preventing the disclosure of investigative reports and witness statements pertaining to the fatal shooting of a criminal suspect may outweigh a media organization's interest in inspecting the records under a common law right of access. That's number 4. And that's North Jersey Media Group versus Town of Lyndhurst, 2017. That's a recent one. A newspaper has no right to inspect records that are not open to the public generally. However, where the records in question deal with how the government is operated, a desire to publish the information in a newspaper to inform the public is a legitimate purpose for seeking to inspect them. When the records are public and a citizen has a right to inspect them, a refusal of that right to one newspaper while according it to a competitor is a denial of the equal protection of the laws. Number 7. McCoy versus Providence Journal Company. Federal Court, First District, 1951. So this is long standing. When the records are public and a citizen has a right to inspect them, a refusal of that right to one newspaper while according it to a competitor is a denial of the equal protection of the law. So when they give it to the mainstream media, but they deny it to the little YouTube channel, well, that's a denial of the equal protection of the laws, according to this long-standing case from 1951 in McCoy versus Providence Journal Company in it was a Second Federal District, First Circuit. Sorry, it's 1951. Well, you can research that for homework if you're interested in that one. I want to make sure everyone's still here. We still got everyone hanging out here in the chat. Please let me know. Record search, business right to inspect public records. Statutes may deny the right to search and inspect public records to a business entity seeking access solely for business purposes. So now here's a key word here, solely for business purpose. If it's not primarily for business purposes, this would not apply. But the right to inspect and copy public records may be extended to those who are engaged in the business of searching public records and furnishing to customers the information that is to be gained from those records. So let's see what they say here. That's case 2, Bell versus Compton. Let's see, what year is that? 1903. Direct mail service and versus Registrar of Motor Vehicles, Massachusetts, 1937. So we're talking about some heavy, long-standing law. Oh, great. Beautiful guys here. All right, thanks. Appreciate it. I got to worry, though, because sometimes YouTube likes to play games, or someone does. All right, observation. A requester was not entitled to the non-consensual disclosure of personal information on motor vehicle records pursuant to a court order under the official business exception of a state statute. Although the requester sought information to prepare testimony for a legislative hearing, given that the requester was not acting as a government official but as a private citizen, and no determination was made by the trial court on whether the records were available under the provision in the statute allowing for the permitted use of such information by a non-governmental entity. So number 3 is, if you really need to dig in, this is 2001 referring to the State Driver Privacy Act. This looks like a rabbit hole for any of those that are interested in the motor vehicle end of all this records. Let's continue. Oops. Try to get this off the screen here. Oh, come on. Try a different one there. There we go. Okay. Definition and nature of public records subject to inspection. So now we're going to get down to the definition and nature. Normally this is kind of like the first part of it, but we all have a pretty good idea of what public records are. Now we're going to know exactly what they are. Let's continue. Writings coming into the hands of public officers in connection with their official functions. Make sure that's all there. Yeah. Are generally accessible to members of the public. But an examination of a public record disclosure request first requires determining whether the documents in question are documents of public bodies subject to public inspection. Interesting. The request first requires determining whether the documents in question are documents of public bodies subject to public inspection. All right, here we go. That's number 2. Let's see what that is. 2013. Oh, ooh boy. Billings Gazette versus City of Billings, Montana, 2013. Very current. That's interesting there. Let's read this one more time. An examination of a public record disclosure request first requires determining whether the documents in question are documents of public bodies, subject to public inspection. A public record is sometimes defined as a record required by law to be kept or necessary to be kept in the discharge of a duty imposed by law or directed by law to serve as a memorial and evidence of something written, said, or done, or a written memorial made by a public officer authorized to perform that function, or a writing filed in a public office. The elements essential to constitute a public record are that it be a written memorial, that it be made by a public officer, and that the officer be authorized by law to make it. So there's a high bar for something to become a public record. But that being said, it's assigning responsibilities because, again, we're here for accountability, and that's the whole purpose of what we're looking at here, the right to inspect public records. And we need to be able to protect that right, and this is how we're able to do it, by making sure we have transparency and accountability throughout the board. For the purpose of a right of inspection, public records can fall into one of three categories. All right, here's our checklist. Get that pen. 1. Those that cannot be closed and must be open to the public. So the records that cannot be closed. 2. Those that a public body has discretion to close but are open unless the public body takes affirmative action to close. And 3. Those which are closed by statute or rule and cannot be disclosed under state law. Isn't this great now? I want to look up the word close. Disclose. Did you ever think you would be used this way? All right, give me a second here. Let's see if we can find. Boy, a lot of close. It's fun. All right, 1. Or close. Close. All right, close. Here we go. Page. Let's get to, Black's Law. Okay. Here we go. Let me just back out a little bit here. Actually, do this. How about this? All right, perfect. Close. Verb, to close. Well, let's look at the noun first. A close. An enclosed portion of land. The interest of a person in a particular piece of land, enclosed or not. 3. The final price of a stock at the end of the exchange's trading day, the close. Got it. Now, close, the verb, transitive. Or no, I'm sorry, it's not, it's just a verb. Let's see, 13th century, to conclude, to bring to an end. The case was closed. To conclude, discussion, or negotiation about, close. Hang on. Closed. 13th century, of a class or organization confined to a limited number. A closed. 2. Proceeding or gathering conducted in secrecy. A closed hearing. Here we go. There we go. We're getting better now. So this is under the 13th century. Conducted in secrecy. So let's find out where disclosed is what we were really looking for, wasn't it? seems like this should be the same root, right? Disclosed. 559. Okay, here we go. Disclosure. The act or process of making known something that was previously unknown. A revelation of facts. Complete revelation of all material facts. Oh, here we go. Public disclosure of private facts. The public revelation of some aspect of, okay. Let's see, disclosure rule. Federal rules of civil procedure requires a shift away from the traditional method of obtaining discovery through the service. All right, that's not it. Initial disclosure. Patents, disclosure. Okay. Well, I just want to make sure there wasn't a special legal definition of it in this context. Now we know. So we're talking about the secrecy and such. Those which are closed, right? That's being secret by statute or rule cannot be disclosed, made released to the public under state law. The common law right to inspect public records extends to any document made by public officers in the exercise of public functions, or a written memorial made by a public officer within the officer's authority, and can reach a wider array of documents than a statutory counterpart. A statutory standard does not determine the outcome of a common law request for disclosure. Okay, so we're not looking at this. So, reminder. Whether a document is a public record that may be inspected is a question to be resolved by balancing the interest of the citizen in knowing what the servants of government are doing and the citizen's proprietary interest in public property against the interest of the public in having the business of government carried on efficiently and without interference. The citizen's proprietary interest in public property against the interest of the public having in the business of government. So remember, we're talking about, citizens' proprietary interest in public property against the interest. So we have an interest in public property against the interests of the public having the business of government carried on on efficiently and without undue interference. So we're concerned about our public property, but we can't do it in a way that's going to interfere with efficient business of government. Interesting. Citizens' proprietary interest. Another interesting thing here in property, public property. So, interesting stuff here to dig deep. And again, this is one of our reminders. Whether a document is a public record may be inspected is a question to be resolved by balancing the interests of the. So we have a citizen knowing what the servants of government are doing with a citizen's proprietary interest in public property. Knowing what they're doing against the interests of the public having and seeing the government carried on with undue interference and carried on efficiently. So they have to have particular and specificity in how there's a particular interference with the efficiency of government business being carried on because the interest of the citizens knowing what their servants of government are doing with the citizens' public property. Essentially, it's the citizens' property. We want to know what these servants are doing with our property, right? And the only way they says, no, don't bother us because you're going to make us mess it up. You're going to mess up with our efficient business of taking care of that property. Interesting concept, isn't it? So this is considered a reminder on the American jurisprudence for you to think about when you're doing this kind of stuff. if you did have a case in litigation or anything like that, what a great perspective to have when you can pull these things out. You're not going to read this in a statute. You're not going to read it in a code. You need to have the understanding to look for it and be able to then write it effectively so that the court can enter it into a record and then move the court in your favor. Let's continue. A statutory provision requiring that a requester be given access to the requester's record or to any information pertaining to the requester which is contained in the system gives parties access only to their own records, not to all information pertaining to them that happens to be contained in a system of records. For an assemblage of data to qualify as one of the requester's records, it must not only contain the requester's name or other identifying particulars, but also must be about the requester. Interesting here, huh? Requiring that a requester be given access to the requester's record or any information pertaining to the requester which is contained in the system gives parties access only to their records. This is kind of let's see what this is going to. U.S. Marshal Service, D.C. Circuit, 2007. So this looks like a convoluted thing here. Let's read this one more time. See if this would apply to something that we might encounter. A statutory provision requiring that a requester be given access to the requester's record or to any information pertaining to the requester which is contained in the system gives parties access only to their own records, not to all information pertaining to them that happens to be contained, for an assemblage of data to qualify as one of the requester's records. It must not only contain the requester's name or other identifying particulars, but must also be about the requester. So this is something that looks like it's a personal record thing that might include references to the requester in that you're looking for. Might be personal records, Marshal Service. This is something worth looking into if you are interested in that thing, and it is a federal case, so let's continue. Preliminary investigation data accepted for public records inspection. All right. So, material gathered by way of preliminary investigations does not become public record before some official action of approval or disapproval. Look at this. A lot of stuff here. 1967, property appraisals made at the request of the city council to assist the city in deciding whether to adopt an urban renewal plan, but not yet acted on, were not public records. Oh, wow. Real estate appraisals from private experts, which a county park board secures for use in land transactions, are not records that a member of the public has a right to inspect. That's 1970. 19, transfer denied, transfer to, ooh, okay. We're getting some pretty heavy stuff here now. Material gathered. All right. By way of preliminary investigation does not become a public record before some official action of approval or disapproval. So a record has to be approved or disapproved first before it becomes a public record. Or the investigation is closed and inactive. So it has to be, let's see here. So if there's a preliminary investigation until, all right, approval or disapproval of the public record. Results of a preliminary investigation aren't a public record unless there's an action of approval or disapproval, or the investigation is closed or inactive. And here's a different definition, I think, of closed. We're not talking about secret. We're talking about the end of a project or the end of an investigation. However, the fact that a governmental agency is in the process of collecting data may in itself be a circumstance justifying the imposition of restrictions upon the inspection of those records by the public as if the use of the data by persons outside the agency would unduly disrupt the investigatory process, as we all have seen when it comes to body cam release. So what I gather from this is that it may behoove somebody, if they were going to file a complaint with an agency and they wanted to perhaps review body cam footage as a method of pre-discovery before they file a case, it would be a good idea to do those public record requests and get those records before you file the complaint, because once a preliminary investigation is initiated, then they don't necessarily have to release those public records now, or part of an investigation that now it's become public records. They may use that as a reason that those public records now can't be released because they're part of a preliminary investigation, and the investigation decided to disapprove release of it. And that could override the public's access because there would be a circumstance justifying the imposition of restrictions upon the records by the public, because it would unduly disrupt the investigatory process. And they just weigh this. It's like they might be right, they might be wrong, but there's be more harm in giving it to the public instead of waiting out the investigatory process. And the time factor here, right, determines whether something's going to cause a larger disruption to the public or to the process of investigating. So I kind of understand this. This makes sense. And this is number 3. 1961, of course, these older cases do make sense. What state was this? Oregon. Okay. Also, drawing a distinction between writings representative, tentative actions, and those memorializing ultimate actions has been held objectionable, not only because it is inconsistent with the principle of public writings freely available for inspection, but also because it provides a device by which a public official can hinder a citizen's legitimate attempt to obtain writings that are clearly within the strictest definition of a public record. I like that. Writings representing tentative actions and those memorializing ultimate actions has been objectionable. There's drawing a distinction because it's inconsistent with the public writings freely available, but also because it provides a device. It provides a device by which a public... See, this is the language we need to use. Are you trying to use this as a device to hinder my legitimate attempt to obtain public records? And this is in the strictest definition of public record, number 4. Same case. That's going to be a good case law to look for public records. And of course, you're going to find this in American Jurisprudence too. It's another volume as well. But 1961, McEwen versus Holm, Oregon. Beautiful. So we see here, rights to access of public records runs deep. Then we have judicial or court records subject to right of inspection. So federal and state constitutional rights ensure public access to court records, as well as court proceedings. The core concern of the constitutional right of access to judicial records is to guarantee the public's right to observe the operation of the courts and the judicial conduct of judges. Wait a second, let me read this again. The core concern of the constitutional right of access to judicial records is to guarantee the public's right to observe the operations of the court and the judicial conduct of judges. Number 3. This is a good chapter here, huh? 2013, 2010, and this is Washington. The 2013 also Washington. Good. State, Washington State. All right, we all still here? We're getting some pretty juicy stuff here. The principle of public access to judicial records furthers not only the interests of the outside public, but also the integrity of the judicial system itself. The right to public access serves to promote trustworthiness of the judicial process, to curb judicial abuses, and to provide the public with a more complete understanding of the judicial system, including a better perception of its fairness. I need to take a breather after reading that one. Yeah, I'm trying to figure that out too there, Archangel, because this seems like, let's reread some of this here, because that's pretty profound. The core concern of the constitutional right of access to judicial records. It says somewhere else here I saw. It was, no, it was, yeah. The operations of the court and the judicial conduct of judges. Now remember, public records are a written memorial, so this is really public records. Nonetheless, all court proceedings should have a transcript. Therefore, if it's the only way we can observe the operations of the courts are through their transcripts, so it seems that they should all be public record. The principle of public access to judicial records furthers not only the interest of the outside public, but also the integrity of the judicial system itself. The right to public access serves to promote trustworthiness. So you can see if they somehow deprive you of the right to public access, then it promotes untrustworthiness of their whole process, right? We need a right to public access to curb judicial abuses. You know, public access to judicial records provides the public with a more complete understanding of the judicial system, including a better perception of its fairness. So we get these great words here: fairness, trustworthiness, integrity, and we got to be worried about to curb abuses. We want a more complete understanding and a better perception of its fairness. This is all one sentence. Public access to court records promotes openness, transparency of process, and accountability, and should be broadly construed. Intent. Let's look at number 5 real quick, and we'll get back there. And that's Cincinnati Enquirer versus Lyons, 2014. Somewhat new. Heavy stuff, guys. Let's look at this observation here. Indeed, Spike. Public access to records of the judicial branch may be subject solely to the rules and decisions of the courts, instead of other statutes. Courts have inherent discretionary authority over their own records insofar as they pertain to the business of the court and when essential to the proper administration of justice. Insofar as they pertain to the business of the court, not the business of the people, and when essential to the proper administration of justice, when essential. Remember specificity and all these other words? We have essential here too. Particularly, essentially. There is a presumption that the public is entitled to have access to judicial proceedings and court records, resting on a presumed benefit from public access, and a strong presumption exists in favor of public access to court records in ordinary civil trials, as the public has an interest in all civil cases in observing and assessing the performance of its public judicial system. Sounds like it's common sense to me, doesn't it? In other words, a common law presumption of public access exists with respect to public judicial documents. However, the public does not have a presumption of access to documents that do not bear directly on the court's adjudicatory functions. The party seeking to help judicial documents the party seeking to keep judicial documents sealed must make a showing sufficient to overcome the presumption of public access, showing good cause, or that suppression is essential to preserve higher values, higher than the presumption of public access, so higher values, oh boy, and is narrowly tailored to serve that interest in considering factors applicable under an applicable test for a balancing of interests. Remember we did that balancing test before, whether the release of information was more in the public's benefit or if it's more undue to functioning of government, etc. So there's always these balancing tests you'll find that are throughout American jurisprudence and essential for winning in any court. Practice tip, I love these. The right of disclosure applies only to those documents that qualify as a judicial record, presenting a question of law and an exercise of the sound discretion of the trial court in light of the relevant facts and circumstances of the particular case. Nice. Does that make clear sense for everybody? We read all that just to get to this so we can understand how this applies. This is where the rubber meets the road. The right of disclosure applies only to those documents that qualify as a judicial record, presenting a question of law and an exercise of the sound discretion of the trial court in light of the relevant facts and circumstances of a particular case. So that's your, is it a judicial record? It's right there. Is it presenting a question of law and an exercise of sound discretion of the trial court, right? So there it is. Very clear language, and if you are posing this as your premises or in your pleadings or motions, etc., it's very easy to understand, even for a judge. As a rule, documents filed in court are open for public inspection unless an exception applies. As a rule, documents filed in court are open for public inspection unless an exception applies, as in cases of specified confidential personal information. The key to distinguishing information to which an open court's provision of the state constitution applies is not the act of filing, but whether the information becomes part of the court's decision-making process. There we go, the decision-making process of the court. A sufficiently established exception to disclosure will warrant the sealing of a record. It has to be a sufficiently established exception to disclosure. That will warrant a sealing of a record. The compelling reasons standard for sealing public records, whereby the general presumption of access to public records has to be outweighed by the compelling reasons supported by specific factual findings, derives from the common law right to inspect and copy public records and documents, and to limit this common law right of access, a party seeking to seal judicial records must show that compelling reasons supported by specific factual findings outweigh the general history of access and the public policies favoring disclosure. Anyone, not just a litigant, can move, apply, or petition to unseal any court record. Anyone, not just a litigant, can move, apply, or petition to unseal any court record. Number 26. Let's look at this. Marriage of Nichols. 2010, 4th District in California. Oh, figures. Let's see here. Okay. The public right to have access to court records is not absolute. The 3 exceptions to the general rule that records used in court proceedings are open for public inspection are, here's our checklist. 1. A statute authorizes confidentiality. 2. There's a showing that disclosure would infringe on a constitutional right. Okay, that's pretty clear. Or 3. A court uses its inherent power to preserve and protect the exercise of its judicial function when an administration of justice requires it. And the right of access, only 3 reasons. 1, there's a statute that authorizes confidentiality. 2, there's a showing that would infringe on a constitutional right. Or 3, the court uses it, this is the one they did, inherent power to preserve and protect the exercise of its judicial function when the administration of justice requires it. The right of access to judicial records under a state constitutional provision requiring the open administration of justice did not extend to documents filed in support of a motion for summary judgment in an accounting malpractice action, where the case was settled before the trial court began to consider the pending summary judgment motion and the sealed documents filed in support of it. As the court did not read or decide the motion and did not consider the sealed documents for any purpose, the documents did not become part of the court's performance, which the public had a constitutional right to scrutinize. So this is case 2029. We'll come to that later. There's also authority holding that although a defendant, as a member of the general public, has a right to inspect jury material in the clerk of court's possession for the purpose of determining the validity of the selection of grand and petite juries, the defendant does not have the right to copy or remove any document from the courthouse. Wow. Okay, here we go. Practice tip. Good stuff. There is authority holding that an order denying a request for public access to judicial documents constitutes a collateral order from which an immediate appeal may be taken. Number 31. So, cumulative supplement cases. Documents that were attached to a plaintiff's supplemental brief. So here's some cases here. Compelling reasons are needed to seal judicial records. Under common law right to access judicial records, judicial documents are presumptively available to public but may be sealed if a right to access is outweighed by interest favoring non-disclosure. And of course, we just saw here in this great practice tip. This is what it's all about here in American jurisprudence, these practice tips. There's an authority holding that an order denying a request, so they denied the request for public access to judicial documents, constitutes a collateral order from which an immediate appeal may be taken, meaning you could get right to the appeal immediately if they make that order. Constitutes a collateral order. So whatever this means, I guess it affords you an immediate appeal if desired. So this is something worth looking into deeper. If you were in a case like this and you needed to access that document, that judicial document that they're denying your request to, it would constitute a collateral order. And from that, an immediate appeal may be taken. So that allows you to immediately appeal it. Pretty cool stuff. Lots of stuff to back all this up. All right, and I think we're at 29 now. The municipal and county records right to subject to right of inspection. Let me read this part again. Municipal and county records subject to right of inspection. The records of county and municipal governments pertaining to the manner in which the business of the unit of government is conducted are public records for the purposes of a right of disclosure. A state public records statute may require all county and municipal records be open for personal inspection and copying by any person. Person could also be a business. The rule that the interest of a taxpayer is sufficient to entitlement for the examination of public records is, in some jurisdictions, at least applied with particular frequency to demands by citizens of taxpayers of municipalities to inspect public records. Municipal and county records open to public inspection include the assessment of and tax records and records of expenditures of public funds. Let's read this part again. Municipal and county records open to public inspection include the assessment of tax records and records of expenditures of public funds. A public official has a common law duty. The public official servant has a common law duty to create and maintain for public inspection and copying a record of the terms of settlement of any litigation brought against the public official or his or her employees in their official capacity. Common law duty to create and maintain for public inspection copying a record of the terms of settlement of any litigation brought against that public official or his or her employees in their official capacities. They have a duty to create and maintain a record of the terms of settlement. That's number 7. Affiliated Trades Foundation versus Regional Jail and Correctional Facility Authority, 1997. That's in West Virginia. Oh boy, West Virginia. Regional Jail and Correctional Facility Affiliated Construction Trades Foundation, maybe? Whew, heavy stuff here. Let's read this one more time. This is deep. A public official has a common law duty to create and maintain for public inspection copying a record of the terms of the settlement of any litigation. The settlement of any litigation, they need to have a record of the terms. They need to record the terms of their settlement of any litigation brought against that public official. Against the public official, has to keep it himself, herself, or any of his or her employees in their official capacity. He or she must create and maintain for public inspection. Must. It's a duty. It's a common law duty. So it might not even be written in the statute, but it's a common law duty that if there is litigation, that they must create and maintain a record of the terms of settlement. Powerful stuff here we're learning from American jurisprudence. Powerful. Then we get to state records subject to the right of inspection. And we're going to move right through this one. Generally, state public records can be accessed by the public, subject to policy considerations weighing against unrestricted access and mandatory statutory exceptions. A state constitution may establish the right of inspection and copying of public records of the state, meaning any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf. And a state public records statute may require all state records to be open for personal inspection and copying by any person. Wow, that's very broad. Did you see this? The state constitutions may establish the right of inspection and copying of public records of the state, meaning any public record made or received in connection with the official business of any public body, any public officer or employee of the state. Or persons acting on their very behalf. Contractors and state, so contractors, any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf. And a state public record statute may require all state records to be open for personal inspection and copying by any person. So that depends upon your state. Worthy of looking into. The common law right to inspect state records that are of such a nature as to be of interest to the public in general is a right that belongs to each citizen and taxpayer of the state. However, a common law right of access to state public records is subject to a determination that a closure could have serious effect on agency decision-making and investigatory proceedings. The disclosure of state, quote-unquote, C corporation tax records was not warranted in light of a statute protecting the confidentiality of the records absent a constitutional challenge to the statute. So that's a state issue there. Gulfstream, Florida, 2014. That's number 3. Which one was that? The state may establish a right of inspection. Yeah, that's Florida. Beautiful. We have West Virginia in there too in 1965. Okay, nothing really. ESPN Productions versus Indiana Department of State Revenue, 2015. That was footnote 1. Generally, state records can be accessed by the public. So Archangel says, for example, if something is under investigation, maybe you could elaborate a little bit more on that question, because I've kind of been through this whole section here. There are a few different topics there. What do you mean exactly if, for example, which example are you talking about? That'd be the last section, I believe you meant, right? Because this section here, we were talking about the judicial records. Let's see what's the next section here. Secret or privileged matters in public records. So secret or privileged matters in public records. This should pretty much get to the other part of it, the secret records. The right of inspection of public records is not absolute or unlimited and does not extend to public records or documents which public policy demands remain secret, such as trade secrets, and documents within the scope of privilege, such as the attorney-client or attorney-work product privilege. Wow, I've never heard this one. Oops. Where'd it go? Oh, Lord. Trade secrets and the documents. Okay, attorney-client or attorney-work product. So what I was getting out of this, if it's under investigation, it may not be available to the public if the court decides to use their authority, right, to prevent that disclosure. So it would be up to the court to decide, I guess. They could not approve the release, I think it was. They approve or not approve. So that would be a court record, though, that we were talking about. Now, the court record could involve a public record, and then the court determines, oh, but that public record is involved with this case. And so now we're going to use our judicial discretion to say that that public record now has to be made denied for public access until we're done with our investigation, because it would interfere with the due process of justice or inhibit the workings of the court. But then they have to be particular about how that would happen. But yes, what you stated here, Archangel, is accurate from what I understand. Okay, let's continue. Good stuff here. So here's another one I've never heard of, the attorney work product privilege. So let's read the state sentence again. We'll look at this on our own time because I'm not too sure what this is going to involve, but all right. One moment here. Okay, so yeah, this the right of inspection of public records is not absolute or unlimited and does not extend to public records or documents in which public policy demands remain secret, such as trade secrets, very good, and documents within the scope of privilege, such as the attorney-client or attorney-work product privilege. The judicial deliberations privilege, ooh, that's another good one. A medical deliberative materials privilege, yep. Oh, of course, you heard this one, the executive privilege. However, these privileges are not absolute. Woohoo! What was this called? Yeah, privilege. Okay, so they're not absolute, are not absolute. It doesn't say they may not be, it says they are not absolute. The party seeking disclosure of privileged records under a common law right of access must show particularized need. Here's that word again, particularized need. And establish that its need for non-disclosure outweighs a plaintiff's need for disclosure under common law right of access. Hey, we got the disciple in the house here. Disciple of the Messiah 1, welcome. We're into some real juicy stuff here today. All right, let's continue. So this is really nice. It must show. So seeking disclosure of privileged records, right? These are privileged records or things like trade secrets, executive privilege, judicial deliberations privilege, medical deliberative materials privilege, right? Oh gosh, freezing in Philadelphia. I was actually sweating at night here in Florida. It's beautiful out here. The party seeking disclosure of privileged records under a common law right of access must show particularized need and establish that its need for non-disclosure outweighs plaintiff's need for disclosure under common law right of access. And we went over last night over the common law right of access. In a court's review of a claimed privilege, when a citizen seeks government information, it should not treat the privileges as sacrosanct, particularly in the light of the presumption of openness, and a reviewing court must examine whether the claimed privilege in a given document is sufficient to keep that document from public disclosure. A reviewing court must examine. It's a reviewing court. See? A reviewing court must, so it shows here that in a court's review of a claimed privilege, when a citizen seeks government information, it should not treat the privileges as sacrosanct, particularly in the light of the presumption of openness, and a reviewing court must examine, so the court doing the reviewing, I get it, whichever court it might happen to be, must examine whether the claimed privilege in a given document is sufficient to keep that document from public disclosure. So back again, it's in the court's discretion. Courts have developed a three-part test, perfect, to assess whether a party has articulated a sufficiently compelling particularized need. I love this language here. Articulated a sufficiently compelling particularized need for disclosure of a privileged public document under common law. Here's our test of that tongue twister. The extent to which the information may be available from other sources. Okay, so if it's available from other sources, then they really can't, prevent the disclosure. 2, the degree of harm that the litigant will suffer from its unavailability. And 3, the possible prejudice to the agency's investigation. Number 12. This is great stuff. Wilson versus Brown, New Jersey, 2009. All right, we're getting some heavy knowledge here. The attorney-client privilege protects only those disclosures necessary to obtain informed legal advice. Wow. Which might not have been made absent the privilege. And the work product doctrine depends on the type of work product being sought. So the attorney-client privilege protects only those disclosures necessary to obtain informed legal advice, which might not have been made absent the privilege. So if it has to have something to do with informed legal advice that wouldn't have been obtained had you not had the privilege of privacy there or privileged information. So not everything you tell an attorney is necessarily privileged by the attorney-client privilege. And the work product doctrine depends on the type of work product being sought. These are all very specific to the subject matter. The government's interest in maintaining confidentiality under an executive privilege claim must be weighed against the interest of those seeking discovery of the material. But executive privilege precluded disclosure under the common law right of access to government documents of email and other documents regarding correspondence between a state governor and the president of a local union made during the course of collective bargaining negotiations. Jeez. The governor. Oh my gosh. 15. Oh gosh. That's Wilson versus Brown. Yeah, in 2009. Goodness gracious. When the state obtains access to private property in the form of genuine trade secrets or other confidential proprietary information by compelling its production for filing with a governmental regulatory agency, this sounds like with fracking when they wanted the solutions, whatever chemicals they were using to do the fracking, the hydraulic fracturing. There was trade secrets they claimed privileged to not let the government regulatory agencies know what compounds were in those hydraulic fluids. And the regulatory agency was concerned whether they were dangerous to the aquifer. But remember, we're in a court of law, so when the state obtains access to private property in the form of genuine trade secrets, and I'm sure they were able to show they were genuine, and they were trade secrets, or other confidential proprietary information by compelling its production for filing with a governmental regulatory agency, the information status as a trade secret or confidential proprietary information remains unchanged. But in determining whether certain information constitutes a trade secret, the agency or court will necessarily determine whether the documents are subject to the public's constitutional right to know. 16. Great Falls Tribune versus Montana Public Service Commission, 2003. I bet that has something to do with that. Could be wrong. A statute mandating public disclosure of insurance rates and other factors that might impermissibly affect availability of insurance established absolute rule in favor of public disclosure, and other statutory exemptions from disclosure did not apply, and thus information contained in the insurer's community service statements was subject to public disclosure, even if the statements contained trade secrets, as disclosure furthered the statutory purpose of fostering consumer participation in the rate setting process. Okay, good. It says disclosure furthered the statutory purpose of fostering consumer participation in the rate setting process. Because remember, the insurance is set by, the rates are set by the commissions, usually some type of consumer protection commission or something of that sort, depending on the state. Proceedings before a grand jury are generally secret. Okay, makes sense. Here's a statutory privilege for medical review committee records and materials supplants any state common law right of public access to information regarding such records and materials. So medical review committee records, materials supplants. So they're statutory privilege. Remember we were talking about statutory privileges? That's one of them there for medical review committee records and materials. Excellent, excellent material. All right, we're going to leave it off of here because now we're getting into confidential communications in public records, and we've already covered all the rights. So it's just been a tremendous stream here with everybody. I'm glad you all came here to participate with me on this. This has been a tremendous learning experience for me as well. Let's see, I just want to see where we're leaving off from here on page 78. And that way, if we do want to continue from here onto the confidential communications in public records, we can. But I believe in these parts that we've done up to now, we've covered such a tremendous area of public records to the point where I think we would be heads and shoulders above 99.99% of the Esquires out there that are involved with this, because let's face it, they're not of interest to anyone that's out there for monetary gain. Public records are there for the people to ensure that the government's functioning in their best interest, and it keeps the government accountable, as we saw here, and faithful to what they claim to be doing, and to ensure that they're performing their duties in the public interest. There's no other way we can know. There's no one else checking on them but us. So it behooves all of us to engage in public record research and to doing our FOIAs and to doing this continuously, because this is truly one of the powers the people have to make sure the government is our government and the courts are our courts. So again, I want to thank everyone for being here. You guys are really what makes it possible for me to keep doing this and to keep learning. And yes, we're all the tribe. We're all a tribe of ideas. We all agree on this idea of freedom and liberty and a way of securing the peace through the justice and American jurisprudence style of justice. To this day, what I have seen is the highest form of exercising this type of freedom. So again, I want to salute you all for joining me on this. And please stay subscribed and hit that bell notification so we can keep this learning process and this journey continuing with everyone here, and let's keep this family growing. Again, I want to salute you all, and peace out.